Hi, I'm Ruth George, and this is the Good Life and Legacy podcast, where we explore answers to the questions, how are you creating a great legacy by living well, planning well, and supporting those that you care about. And today I am joined by Dr. Beyer. Dr. Gerry W. Beyer joined the Texas Tech University School of Law faculty in June 2005 as the first holder of the Governor Preston Smith Regents Professorship. Previously, he taught as a professor or visiting professor at many other law schools from coast to coast and in Australia. Law schools, student organizations, and other prestigious organizations have honored him with numerous outstanding and distinguished accolades and awards. Professor Beyer received his JD from the Ohio State University and his LLM and JSD degrees from the University of Illinois. He is a member of the Order of the Coif, an academic fellow and regent of the American College of Trust and Estate Counsel, a member of the American Law Institute, and was inducted into the Estate Planning Hall of Fame. The Uniform Law Commission recently appointed Professor Beyer as the reporter for a new act addressing electronic estate planning documents. Dr. Beyer is the editor of the most popular estate planning blog in the nation and has authored and co-authored numerous books and articles which have covered many estate planning topics. I could go on and on. Let's just say Dr. Beyer is amazing, and I am so honored to have him here. Welcome, Dr. Beyer.
Well, I am honored to be invited to be with you. And please, you can just say Gerry. That is fine with me.
Well, that's hard to say. Okay, Gerry. Well, I have to say, Gerry, that through the many, many years, I have printed out many, many, many articles that you have written, items on your blog, and I have binders like this galore. So you've been in my life for quite some time, but you didn't know it. So I'm very honored and appreciative for you to be here today. So thank you again.
Like I said, you're most welcome. I'm very glad to help you and your listeners.
Oh, wonderful. All right, so we're focusing on trusts. And if you could start us off with a basic definition of what a trust is, that would be wonderful.
A trust is a type of legal relationship that is very, very different from any other type of legal tool that exists. Technically, the way you want to look at it is that the benefit of property is separated from the management of the property. So we take the ownership of the property and we divide it into two halves. The legal title, the legal ownership is held by a person we call the trustee. And the trustee has the obligation to use that property and invest that property according to the person who created it instructions. We call that person typically the settlor of the trust. And that property is used, invested, spent, and so forth for the benefit of the beneficiaries, the people who have the equitable or beneficial title. So when you create a trust, you are called the settlor. The person who manages the property is the trustee. The person who gets the benefit is the beneficiary. A trustee has lots of responsibilities. They're what we call a fiduciary. So they have to manage the property in accordance with very high standards. And if they do not, they will become liable. So being a trustee is somewhat of a pain because there is a lot of potential liability exposure. The beneficiary, on the other hand, gets only the benefit from the property. They do not have the ability to dictate how that property is used or invested normally, and they then get the benefits as the settlor provided. So it's not like they just get an outright gift of the property and can do with it what the beneficiary wants. The settlor, who creates the trust, gets to provide the instructions for how that property is used.
Right. And I absolutely agree and love how you said it's a legal relationship, because so many people don't quite understand trust. And I hear different people saying things that I personally don't agree with. That was absolutely 100% what I would be telling my clients as far as what a trust is. It's a legal relationship, and you're really trying to plan ahead with all sorts of instructions as far as what is, what would be best for the people, entities involved. I think one of the things that I think people worry about with trust is getting stuck with that plan. So can you talk to us about revocable versus irrevocable trusts?
When a person makes the transfer of property and creates the trust, and I like, Ruth, what you said, many people think that a trust is like a legal entity of some sort, like a corporation or a partnership or something. A trust is just a mechanism for holding property where the management responsibilities are divided from the beneficial enjoyment of the property, where with most property that you own, you both manage it and have all the responsibilities of ownership as well as all the benefits, because you have both halves. Here, different people can have different halves. Now, your question was whether or not to make the trust revocable. This is something totally up to your client to decide with regard to what would be the best way of setting this up. If you make it revocable, then anytime the person wants to change their mind about how the property is used, anytime that a person wants to change how the property is used, who the beneficiaries are, what the restrictions are, they are free to do that and regain the property for themselves. On the other hand, there are some benefits they will not receive if it is revocable. For example, it will not be as effective to prevent attachment by creditors later on. If you're creating the trust for tax reasons, you may not achieve the tax benefits that you are seeking.
Right. There's so much to be said as far as that question goes. And I tell you, sometimes I try and explain the difference to clients, and I feel like I keep circling back because it's so overwhelming or confusing. And then to add to it, I'll say you can have a revocable trust with an irrevocable trust, and each serving a different purpose. And this all ties back into what trusts are. They're legal relationships, and you get to make the arrangements as you deem fit. And I think it can also depend on the assets themselves and what would make most sense given the particular assets and what you're looking to do.
And I think it's real important for people to recognize what the reasons are.
Right.
That they're creating the trust, because
Right.
there are different reasons, and the purpose of creating the trust will often dictate what format you want it in. And I also liked what you said in that it's a person might create more than one with different terms, different property, and so on to achieve different results.
Right. And I think it's very interesting that it seems to stump clients about the overall goal of what they're trying to do, because I always will say, I can tell you about the various trusts and the advantages and disadvantages, but I really need to hear from you. What are your goals? And it is interesting how hard it can be for people to understand what their goals are and not get lost along the way.
Do you think it would be beneficial to just spend a couple of minutes looking at some of those goals, some of those purposes, why a trust is a good idea?
Yes.
Because I really like what you said. You have to find out what the client's goals are. What do they want to do? So let's just take a minute and put everything in the perspective of why you're creating a trust. Really, the reason you create a trust is you don't want to just give the property to the person outright. If you give it to them outright, they get the property, they can do with it what they want. There is no protection of any kind. So the main reason that you put property into a trust is to provide for and protect the beneficiaries, because they lack the ability to manage the property for themselves. Maybe it's because of age, maybe they're minors, maybe they lack management skills. I mean, it's fascinating to see that people who win like large lottery amounts,
Right.
millions of dollars within a year or two or three, I think most of them are just as well off or poor off as they were before they won, because they don't know how to manage it. Or people just are willing, they just spend money, or their creditors get it.
Right.
And a second reason, in addition to thus protecting them, it gives you the ability to indicate how your property is to be used. So if you're setting up a trust for your children or grandchildren, you can make sure it's used for education purposes, for healthcare, for housing, for other purposes, and they just don't take the money and go on vacation or buy an extravagant car or something.
Right.
And then when you were talking about avoiding probate, that's a very interesting thing. And I don't know what your situation is in your state, but states vary tremendously with regard to whether probate is a bad process, time-consuming and expensive, or whether it's a very streamlined and easy process. If you're in a state where it is complicated and or expensive, a trust can really make things easier upon death, even if you are not as concerned with those other purposes. And another one you mentioned, which I think is real important, is privacy. Because if you have a will, or if property passes through intestacy, if you don't have a will, everything's on the public record. What the will says, what your property was, how much it's worth, who gets it. But if property passes by a trust, you can achieve tremendous privacy because the trust document is not necessarily going to be on the public record. And a lot of people like that.
Right. And business interests, I think very well should be thought of as potentially going into a trust because, first of all, management during life, but then upon a person passing, we don't have to worry about what's happening with those business interests in the interim while we're scrambling to get our documents ready to surrogates court. We can have the appropriate successor trustee with the right technical abilities and just management abilities to handle the business interests, so we don't see, the business negatively impacted and affected, which affects employees, affects the community, affects a whole bunch of
Ruth, that is real important,
dominoes.
because if property passes through a will or through intestacy, even in the states with the most efficient processes possible, it still takes months.
Right.
And property, not just businesses, but just other assets need management. I mean, if you have a farm, you need the crops to be harvested or fertilized. If you have a ranch, you need to have the farm animals fed. If you have a stock portfolio, you need to manage it. Look at the way things change in the world so quickly. You would need investments managed, stocks managed, and the gap that occurs can cause tremendous problems. Whereas when property is in trust, even if the settlor, the person creating the trust, was the trustee while alive, immediately upon death, the successor trustee takes over, no court involvement, no gap in management. So that's really, really important point.
Right. And I really try and emphasize that with clients, that you could have a situation where a person passes and the next day we can have that successor trustee taking action. I know that sounds a bit morbid, but in reality, that's the idea, is that you can have somebody ready to go and start doing what may be necessary and take very protective measures from the get-go. And I think COVID highlighted some of the difficulties as far as the interim period. There was always an interim period because you have some time where you've got to compile what's going on. Is there a will? Where is the original will? Are there other original wills out there? And who are the people? And what do we have to do? And who passed away? And who can sign? And who's a minor? And who's incapacitated? And we've got to do all of this stuff before we can even get a package to surrogates court that then has to review it. So that was always something to consider. But with COVID, it has certainly only made trust planning, I think, more important. As far as avoiding probate, I think for my clients, I always try and find the red flags. And it's always interesting because we can have a relatively small estate, but the red flags are so bright. And it's not about, in my opinion, the assets, if you've reached a certain asset level, that you deserve a trust, but the idea that you're going to be in a nightmare situation. Like you said, even in those small estates where we have real estate, nobody can keep up with paying the bills, paying the mortgage, paying the electricity, the heat, the this, or that, and the other thing. And we have a small estate that has real estate that's deteriorating. So anyhow, so many reasons to think about trust. And we're going back to that idea of what is your goal. So we could keep talking forever just about that. People are pretty familiar with the idea of setting up a trust while they're still alive. So that goes to what we were just talking about, but not everyone realizes that you can set up a trust upon your death. What do you see as the advantages of setting up a trust during life? And we did talk about that a bit.
Well, there are pros and cons of setting it up during life or at death. But going back, Ruth, to what you said at the beginning, it is whatever the client's goals are, determines which way to do it, or even both. If you created while you're alive, well, you've immediately made sure it's all working. Because while you're alive, you got the trustees serving, even if it's you, but you got the successor named, you got all the title in the correct hands. You already have distributions to the beneficiaries going on. Everything is sort of already working. So when the horrible event of your death happens, it's just the new trustee steps in. Like you said, it could be the next day, and the trust and everything continues to go smoothly without a gap. However, there may be times where there's no real need for the trust to be doing all of this while the person is alive, and therefore they can have the property just pass into a trust after they die, especially when the trust would only be used as a contingency. As an example, let's assume your goal would be to leave everything to your spouse. Well, maybe you don't need a trust while you're alive because everything is going to your spouse. But if your spouse were to die first, then you'd want it all in trust for your children. So in that point, the will might provide that everything goes to the spouse. But if the spouse dies first and there's minor children, then the property goes into a trust created in the will.
Yeah, that's a perfect example. And people also don't realize that you can use a trust in your will for asset protection planning purposes, where as opposed to somebody getting outright distributions, a sum of money, the monies are distributed in trust, or whatever, the property is distributed in trust, and that trustee named in your will then goes ahead and does what needs to be done. As far as the will goes, you can certainly put in a trust within the will so that in the event you think it might be that your spouse is in a nursing home, you really don't want the funds to go right over to that spouse who's then just seen those funds be completely devastated and over to the nursing home. So there can be a reason to set up a certain type of trust. Or you have a disabled beneficiary, you certainly want to set up a certain type of trust in your will. So those are some examples, I guess you would say.
Sure. Let's just talk about both of those a little more, because those are such great examples. Think about if you give property outright to someone, whether while you're alive or upon death. At that point, they can do with the property whatever they want, meaning all of their creditors for whatever they're in debt for. I don't care whether it's a car accident or because of credit cards or whatever they're in debt for, they then have the ability to reach that property. But if you put property in trust for like your children, and the distributions are only made to the kids for certain purposes, you can arrange it so that the creditors have no ability to reach it. For example, you don't give the money, you don't have the trustee give the money to the child to pay rent, mortgage, taxes, utilities, tuition, or whatever. You have the trustee pay the money directly. And the trustee pays the money directly to these people. The beneficiaries' creditors will not be able to reach the property. So that is a great idea. Now, Medicaid planning, I don't know about your practice, but as far as I'm concerned, because of the huge complexity of doing Medicaid planning, I know enough to know about it and to send people to an expert who does that, because that takes some special planning. But of course, if you do have any type of special needs beneficiary, it can be very important to try to keep that money from being used to pay for things that would normally be covered by the government.
Right. So there's Medicaid asset protection trusts, which I think in certain circumstances are warranted. I think one of my concerns is that I want to make sure it's the client's goals.
It's a very valid concern. But again, it all goes back to the first thing you said. What are the client's goals? What do they want?
Right.
And of course, that's one thing. It's so important that clients sometimes have a difficult time explaining, because we can carry it out, but we need to know what it is.
Right. And I think that's what I try and even help people kind of start thinking about before they even get to me if I can. So yeah, it's a big thing. All right, let's talk about how we need a trust and a will and how they intersect with each other and complement each other, because often I get, well, if I'm doing a will, what's the point of doing a trust, or vice versa? And so I do a lot of explaining there. So what are your thoughts with that?
Okay. If you create a trust while you're alive, the trust only has in it whatever property you have transferred. You must transfer the land by a deed. You must turn over the personal property like a collection physically. You must register bank accounts, stock funds, or whatever. You're unlikely to be able to transfer everything you own into a trust. So there still will be property that needs to pass through your estate. So you need a will to take care of that property, even if all the will does is leave all the property to the trust that you've already created. And remember, sometimes property will arise at the time of death that didn't exist while you were alive. Many people die in car accidents or other types of accidents, medical malpractice, things like that, that might give rise to a large survival claim. And it would be good to have those things into the trust as opposed to just passing under the will. But you always need a will, regardless of whether there is a trust or not. You need a will because something might not be covered by the trust. And if you did create a trust and wanted to have it to be everything, you can have what we call as a pour over provision, a provision of your will that basically could leave everything to the trust, but you always need that will.
Right. Those are the examples I always give. There'll always usually be something, a tax refund, a homeowner's insurance refund at the very least. And then you've got the probably, the bigger items would be, personal injury, wrongful death, anything. So always need a will, correct. And here in New York, our small estate threshold relatively recently went up. So now if you have a small estate, you still have to follow the terms of the will. If it's valid on its face, you file it with the court, but the executor named in the will is the one to go ahead and even do the small estate proceedings. So you've got the right person in charge. So there's a lot to it. All right. So as far as legacy planning, that's something we talk about on this podcast. How do you think trusts factor into legacy planning?
Well, first of all, what is your definition of legacy planning?
Right. Good question. So I think of legacies as something that somebody does with forethought, and the people who then benefit from that forethought have this belief that somebody cared about them. They set up arrangements in such a way that they feel loved. And it continues on in sort of good spirit, good thoughts, as far as that overall planning.
Well, just think about what you said. That is exactly what a trust is designed to do, to show that you, first of all, provided for that person as opposed to leaving the property elsewhere, and provided for them in certain manners to be sure that they had money for long term. For example, not having the trust end until they reach 30, 35, 40 years old. So to be sure that during those formative years, they have money for education, money for getting a house, starting their family, etc. So using a trust as part of this type of legacy planning, as you're describing, is a really significant and extremely useful tool.
Yeah, it really makes one think about that person who took that action and go, wow, they really thought about doing that. They took the action and I'm now benefiting from it. And I hope it makes the individual who's benefiting have a sense of duty towards fulfilling a certain legacy of their own, not squandering things and being a good steward of the legacy. So
that's right. And you could even impose various conditions on the receipt of the money to sort of encourage that legacy to continue.
Right. Did you hear of the Bowlen Trust? No, of course you did, because it was on your blog.
That's true. I don't know anything more about it, though, than what was written there.
No, that was good, though. It was, they couldn't find a suitable successor trustee within the family, so they're selling the team.
Yeah, that is it, both in such a huge case, but there was just another small case that one of the attorneys that I know was talking about, that they couldn't find anyone to be trustee. They couldn't find any individual. The banks wouldn't accept it. Nobody, and this was not a fancy case like the team case. This was just, they didn't want to do it. It was a really interesting case. They just had to terminate it and distribute the property because nobody would do it. Now, of course, by proper planning, now that's an important point you want to mention. And that is, before you name someone as a trustee, you want to be sure to check with them first and explain to them what the duties and responsibilities are. Because if you are in a case where the settlor, your client, remains the trustee while they're alive and competent, you want that successor trustee who takes over if something would prevent them from serving while alive, some sort of mental incompetency, an accident or whatever, or upon death. They already know what they're supposed to do, that they'll say, yes, I agreed, I'll do this job and I'll step in. The last thing you want is for them to say, no, I would rather not do that. And then you end up with the case of having to go to court to get a trustee appointed. Now it's not going to be someone the settlor trusted, all of those issues. So always check with them first.
Right. And I think that brings up another point, which is that all of this stuff takes planning. And it's not to be just, a boilerplate document. And I did a trust, and why is your fee so high? It's, well, listen, we've got to think about things. We got to think about how this trust is going to function. Who are the people? Let's talk to them, get things lined up. So I really do think it takes obviously a lot of planning to do it right. And then it brings up one other point, which is, in trust documents, you can always state that the last acting trustee may appoint a successor trustee, so there's never any vacancy if that's something you feel you could really trust the people that you've named in there. How do you feel about that?
I like providing provisions for the selection of an ultimate trustee if all the ones that you first named don't work.
Right.
Because otherwise you got to go to court.
Right.
And then you have to spend the court costs, the attorney fees, and so on.
Right.
I know it can't always be done, but I usually recommend naming one or two successor people and then a mechanism of appointing a successor. Maybe a majority vote of the beneficiaries or some other trusted person you have to name it. Or what a lot of people do, at least in my experience, is that the end result is some corporate trustee, somebody that they know will take the job. And yes, you've lost the personal aspects of having a family member or friend be the trustee, but at least it's in the hands of somebody professional.
Right. Now, can I ask you, going a little off track here, what about IRA trusts? And I know with the Secure Act, that's potentially not as interesting to people, or even naming retirement accounts, having beneficiary designations, having a trust named as the beneficiary of a retirement account. And I think it still serves a purpose and is still very valid, but can you share your thoughts on that?
If you don't want the beneficiary to get the property outright for whatever reason, it's a great idea to name a trust as a beneficiary of IRAs, retirement plans, life insurance policies, because all you're doing is getting more money, more property into the trust to be used for your original purposes. There are many people who, when you would talk with them, they'd say, well, I'd love to set up this trust for my children or grandchildren, but I don't have any money now. Well, that may be true now, but upon death, when all of these retirement benefits and IRAs and life insurance come due, you could end up with a very large amount of money in the trust at that point. So I think naming a trust as a beneficiary of these arrangements can be very effective in carrying out that client intent.
Right. Just have to add a couple additional provisions as far as retirement accounts go and how they're treated within the trust. As far as a successor trustee taking over during life, one of the things that I love with setting up a lifetime trust is that you can state who is going to determine when the successor trustee takes over. In other words, it doesn't have to be that a doctor declares the person incapacitated or unable to act. It can be the successor trustee who says this person is unable to act. Tell me your thoughts there.
This is really important because some people say, well, I'll just get a power of attorney that takes effect when I become incompetent, and then that can manage the property. One of the great benefits of a trust is that it provides a possibility of someone managing the property without a gap when you are unable to, either because of some sort of mental condition or simply you're in an accident and in the hospital for a few months. Normally, if you didn't have the property into a trust, you would have to have a guardian, a court-appointed guardian appointed, which is going to take a lot of time, a lot of money, be an embarrassing situation. Usually you want to avoid guardianships. So if you have the trust and the trust provides the mechanism for determining when the successor takes over, then the successor just takes right over and continues doing things without the necessity of getting doctor determinations, court determinations. I mean, right. I've seen situations where the person is clearly incompetent and they can't find a doctor to certify they're incompetent because, they do know their name and they know what day it is and they couldn't manage property, but they're not so far gone that a doctor will sign off on it. And that takes a lot of delay and a lot of problems. So your point is really important.
Right. Yeah. The idea of really creating that nutshell, which hopefully is going to just have all the right instructions when the time comes as far as what needs to be done. As far as tax planning goes, so you can have a revocable trust that can be beneficial as opposed to doing outright gifting where we have a carryover basis situation. We can do a revocable trust where then we have a step-up basis, at least as far as we know now. Even with an irrevocable trust, we can maneuver so that we can take advantage of, if we desire, having a step up in basis with that type of trust. Irrevocable, we can also decide to use our exemption and do a complete gift. So can you talk to us a little bit about some of those ideas as far as trusts being very beneficial for tax purposes, but again, then you're determining what are your goals and what are your assets and some of the tax maneuvering that you can do?
In the past, when the exclusion from estate and gift tax was so much lower than it is now, trust planning for gift tax, estate tax, and for generation skipping transfer tax was essential. And it still is, of course, if you're fortunate enough to have enough assets that you come up to the threshold. Right now, a lot of planning is done to make sure that you get that step up in basis. Because if you just make a gift of property during life, you get a carryover basis. And it's possible then when a person who you give the property to sells it, they're going to be liable for a significant amount of capital gains tax. Whereas if the property transfer is not final until death, we should get then the step up in basis, which allows the appreciation to escape the income tax, the capital gains tax. So tax planning now to minimize taxes is a lot more based upon income tax than it is the death transfer taxes, simply because things have changed. And of course, I don't know, does New York have an estate tax?
We do. One time I looked at all the states and I tried to categorize them because some states have something different. I didn't know that when I was first looking into things. They have, inheritance tax, or, they call it different things. But yes, we have estate taxes, which are the exemption amounts over 5 million. So for the most part, people are not concerned. But I would think there would be some changes for New York in the future, which would lower that, but we'll see.
And so your tax is way lower than the threshold is way lower than the federal threshold.
Yes.
Well, you're going to bring in a lot more people in that. I know that people think 5 million sounds like a lot, but if you're living in New York City or one of the areas, just a condo or a house or not a time, what do you have? You have cooperative apartments, all that type of stuff could have extreme value. And you couple that with a good life insurance policy, you could end up at that threshold a lot faster.
Yeah. So trusts have can incorporate a great deal of tax planning depending on what your situation is and what your assets are. And you kind of have to get into it as far as what your goals are. And you can set up those credit shelter trusts within your revocable trust. It's not just in your will. You can set up disclaimer provisions and all sorts of things. So much to do. What would you say to somebody who is thinking about setting up a trust, but they're not sure? And what would you say about trying to act, sooner rather than later and not let too much time go by as far as continuing to think about things?
Unfortunately, a death can occur at any moment. I mean, you could just be sitting here fine. You could have an aneurysm and die. You could walk across the street and get hit by a car. You could die in a car accident on the way home. I mean, we don't know when the Grim Reaper is going to come calling. And people put things off, and it's going to cause a lot of problems for their family. It's going to cause them emotional problems, financial issues, and so on. So I recommend acting as soon as possible. Yes, I know it is hard to do. I mean, I'll tell you, Ruth, and your listeners too, because I tell my classes, I would stand up in my class and say, everybody needs a will. Everybody needs to do this. You're a fool if you don't. Come on, we all got to do it. And then I would go home and look and see a hypocrite in the mirror, someone who had not yet done it, even though I knew better and was teaching people, lawyers and law students, to do it. And finally, my wife said, you can't be a hypocrite anymore. You got to do it. So I know from personal experience, it's hard to do, but I'll tell you, you're going to feel much better. And remember too, there's a lot of estate planning that is more than just property upon death. We've been talking about this disability planning, and that's really important because really statistics show that if you're under 60, the odds of being disabled in the next year are greater than the odds of dying. So having a trust and other mechanisms in place to handle property management as well as healthcare decisions upon disability is extremely important. So your question was, put it off? No, act now, knowing that everything you do, you can change unless it's an irrevocable trust. But all the other documents, the will, a revocable trust, the powers of attorney, all of that can all be changed, but you're better off to have something in place and then adjust it later as your thoughts change or situation changes. Don't put it off. I mean, if you're going to ask me, the main thing your listeners should take away from this is do the estate planning as soon as possible.
What honesty. Thank you so much. That was awesome. I know it's so easy to talk about what you know, but then you reflect and go, wait a minute, I have to do this too. I've been in those shoes as well. And I actually interviewed my husband's 3 nephews who are young adults. And I think it's important as young adults to start the mindset. And so I talked about that with them. It's not that I think you're going to need these documents tomorrow, but it doesn't hurt to have them. And you're starting the right mindset as you move forward in life. I need to update them or revise them now, or think about them or plan accordingly.
I always think of an estate plan as like a medical physical. You should have a physical once a year just to make sure everything's good. Well, right. You should review your estate plan once a year, because boy, things change. People are married, people are divorced, children are born, grandchildren, people die, people move states, people get different assets. The people's feelings about family members can change. Yeah. So a lot of things can happen, and you want to have an estate plan that is up to date. And also laws change. Just think if they change the laws for the income tax, the step up in basis, and how much the exclusion is for estate and gift tax. I mean, those things could change. Needs to be reviewed to be sure it's always current.
Yeah, that's such a good point. And when you're reviewing it, that's when you have the opportunity then to make changes. And, even with irrevocable trust, let's say if the settlor is still alive and all the beneficiaries are adults and can legally sign legal documents for themselves, there's options and there's things that may be done. But certainly you wouldn't know it if you didn't review it and then reach out as far as keeping up to date with things. So very important. So we talk about making confident decisions on this podcast, and we've really kind of been talking about that as we have gone about speaking about different things. What insights could you provide to help people make confident decisions in using trusts in their estate plans?
It's all of the things, Ruth, that we've been talking about.
Right.
You have to figure out what you want to have happen. See, the trust, the way I view it is the trust is to exercise substituted judgment for you when you can't do it, because either you're disabled or you have died. So you can no longer make the decisions about how your property is used. So you're trying to set it up so that it will continue doing what you would have done if you had remained competent and or still alive. So that's the thing, to try to continue what you would have done if you were alive. And that's how that's how it works.
Right. And I was thinking about this. I think some people think, I don't want to do an additional tax return. And I think, well, a lot of trusts you don't, at least lifetime trusts, revocable trusts, when you're the settlor, you don't have to do you don't do a trust tax return. And it would only be in certain situations, and your estate planning professional would help you where you may have to. But people, I think, have this idea that that's part of what you would have to do in setting up a lifetime trust. And it's not the case.
No, like you said, if you have the power to revoke the trust, that the government treats you as still owning all the assets for tax purposes. So you don't even need to get a taxpayer number for the trust at that point. And if you do, people do this. There are professionals that provide CPAs or attorneys who are skilled in trust accounting.
Right.
And they'll handle it. That should not be a reason that people would use.
Right. Even with irrevocable trusts, you can set it up with the Social Security number of the settlor, just take some planning. But it's so funny, the things that you hear, and even still, we all have to deal with the institutions and the entities once we have these trust documents. And I think it's important to have an attorney who can help you with some of the difficulties that you may encounter when you're retitling assets or doing things with trust planning. So I think that's important to think about. People have to do this with a estate planning professional, somebody, an attorney who knows what they're doing. I have seen so many trusts fail because the property was not properly titled into the trust, Mhm.
or some other requirement wasn't satisfied because people tried to do it themselves with forms over
Right.
the internet or one of those services. You need to have somebody with the skill to go through it to make sure it's done correctly. Otherwise, you're going to end up, what do we call people who do all this on their own? We call them future clients and future business to try to straighten all this out.
Right. Penny wise and pound foolish, right?
Absolutely. That's right,
Yeah.
Ruth.
Well, is there anything else you would like to share about trust planning or estate planning in general?
Well, Ruth, I guess the bottom line is, as we've discussed before, find out what your goals are and implement them. And you have to take action to take care of where your property is going to go, take care of who's going to make medical decisions for you if you cannot, how you want end of life decisions handled. You have to plan for all of this. So many times, if only a small amount of planning had been done, it would avoid years of litigation, years of family issues, if only something had been done very simply. So despite the fact that you think, I got better things to do, I don't want to think about dying or being disabled, I don't really have as much property now, I'm too busy, all those other reasons, they're just excuses. And like I said, I understand because I use them too, but don't do that. Go out and get yourself a good comprehensive estate plan that carries out your desires.
Beautifully said. Well, I'm sure I could talk to you for hours on end. And I just thank you so much for everything that you do. I follow what you do and I try and pay attention to every little thing I can with whatever you put out because you're just amazing. So thank you so very much for being a part of this podcast. I truly appreciate it.
Well, Ruth, I enjoyed this very much. It was an honor to be invited, and I hope that your listeners have benefited from our interchange today.
I am sure they will. They're very lucky to have heard from you. So that is amazing.